officially on the record, and it is recording.
Thank you very much. Good afternoon. For the record, I'm Ann Levinson, Chair of the Washington State Public Disclosure Commission, and I'll be the presiding officer for today's hearings. Today's Thursday, April 12th, 2018. The time is just about 3 p.m. This hearing is being conducted under the authority of RCW 3405, which is the Administrative Procedure Act, WAC 39028, which contains the rules for the PDC, and RCW 4217A, which is the Campaign Disclosure and Contribution Act. I'm participating by phone with PDC staff present in the PDC office in Olympia, Washington, and we are audio recording this proceeding. Let me ask the PDC staff who are present to please introduce themselves for the record.
Kim Bradford, Communications and Outreach Director.
Jennifer Hansen, Filer Assistant Specialist.
Great, thank you both. Just a little bit of background for public understanding. Under RCW 4217A 700, elected and appointed officials are required to annually file what are referred to as reports of financial affairs and gifts. These are also known as F1 reports. RCW 4217A 710 describes what must be reported, and then under Section 120 and WAC 39028.040, a filer may apply for a suspension or modification of one or more of those requirements. In order to do that, the filer must file with the Commission a written request for a hearing to suspend or modify any reporting requirements. The rule encourages the applicant to submit that by the 10th day of the month preceding the month in which the report is due, so that the Commission can take action on the request, and that can be completed before the filing deadline. The Commission may suspend or modify any of the reporting requirements if it finds that literal application of the law works in manifestly unreasonable hardship in a particular case, and the suspension or modification will not frustrate the purposes of the law. Commission may only do this after a hearing is held. An applicant may choose to waive their personal appearance at the hearing if they submit a written sworn statement setting out the rationale for the request. New requests and requests for renewal, if the initial request was granted more than 3 years previously, or if the applicant is holding a different office or position, are heard by the full Commission. Otherwise, renewal requests may be heard by a single presiding officer, and that's what we'll be doing this afternoon. There are 13 requests for renewals of previously approved reporting modifications. All the applicants have waived their personal appearance, so I'll hear these matters concurrently in the interest of judicial economy. Separate orders will still be issued for each matter. Let me note for the record that I have worked with one of the applicants, Senator Peterson, but I do not believe that that will impact my ability to be fair and impartial. So let me begin by swearing in the staff. Ms. Hansen, if you'll raise your right hand. If you swear or affirm under penalty of perjury that the information you'll be providing today in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I will.
Thank you. If you'll go ahead and present each of the requests and verify that these applicants do meet the criteria for this single presiding officer hearing rather than full Commission, that would be great.
I apologize. You'd like me to confirm that they meet this requirement?
Yes, at these 13.
Yes, they do. Their request for modification was last heard before a full Commission and approved within the 3-year time period, and none of them have changed offices since that original reporting modification request was heard and approved before the full Commission.
Thank you, and I appreciate your written documentation of that in the materials as well. Do you want to go ahead and do these by group, by the type of modification requested?
Yes, if that works for you.
All right.
And Commissioner Levinson, if you would, as we go through, if you would like additional information for your purposes or to be read into the record, if you would let me know that. Otherwise, I will limit my reading for each applicant by their name, their position, and then the type of application that they are or the type of request that they are applying for.
Okay. And I've reviewed each of the applications. I've read the materials provided. Are there any other additional materials that have come in since these applications?
There are no additional materials for these 13 applicants today.
Okay, great. All right, go ahead if you would.
The first 3 applicants are requesting a modification that would exempt them from reporting reportable business customers of $12,000 or more during the previous reporting period, which is either the previous 12 months or the previous calendar year. For these particular applicants, all of them are requesting modifications for the previous calendar year, so 2017. The first applicant is William Ayer. He is a regent with the University of Washington. Second applicant, Jamie Peterson, state senator in the 43rd Legislative District. Third and final applicant for this particular type of modification request is Charles Quentin Powers. He is a trustee with Edmonds Community College.
And for each of these, in looking at the application materials, they've each also attested that these entities don't transact business with them in their roles, and that that there's no conflict of interest presented by the non-disclosure
That would
of those business customers.
So that would be correct in most cases. If there was a connection between the office that the applicant holds and the business that they are asking to be exempt from recording all of the reportable business customers, they have identified those. These applicants are not being brought forward to you unless they have identified that very specific connection. So if there is a connection there, it is listed. If there is not, it is identified as there is no connection.
Very good. All right. For these 3 applicants and the request to be exempt from reporting business customers of $12,000 or more, I will approve the partial modifications as requested on the basis that literal application of the law would cause a manifestly unreasonable hardship on each applicant, and that a limited modification will not frustrate the purposes of the Act. And then we have residential address exemption requests.
That is correct. The next 5 applicants are requesting a modification to not disclose an address. As noted in previous full commission hearings, Commissioner Ammons has identified that these are not always residential address. However, the statute and the rule regarding this note different things. Staff is continuing to review those discrepancies and to try to find out the best corrective action to take. So for now, they are being listed as residential address. Each applicant has identified whether it is 1 address or 2 addresses, and those are noted in the cover sheets that are available to the public as well. The first applicant is John Chen. He is a Superior Court Judge in King County. Raymond Clary, Superior Court Judge in Spokane County. Rebecca Robertson, Municipal Court Judge for the City of Federal Way. Lucinda Whaley, who is a member of the Washington State Parks and Recreation Commission. And Robert H. Whaley, trustee for the Eastern Washington University. And I should note that Lucinda Whaley and Robert Whaley are husband and wife. They are requesting modifications that mirror each other. Mr. Whaley is actually a judge at the federal level rather than the state level. So.
All right. There are, in a couple of places, their answer is not articulated to certain questions. The information is provided elsewhere, but perhaps when we conclude this, we can go over some of these. I think the form directs them to only answer certain questions for the residential exemption, and not necessarily aligning to where they're providing the information. So just for purposes of public clarity going forward, we might want to adjust that. All of these, though, are reasonable requests, and I've reviewed the information and will approve the partial modification to exempt the residential address and the adjacent address in one instance, on the basis that literal application of the law would cause a manifestly unreasonable hardship on the applicant, and the limited modification would not frustrate the purpose of the act.
The next two applicants, if you're ready to move on to them, are requesting a modification that would exempt them from reporting business customers. In this case, they are more commonly known as clients of the law firm of which they are a member. This modification allows the applicants to request to not disclose all of the clients or customers of the law firm, but rather a limited amount. They are required to disclose any customers or clients that are already publicly available, as well as those that they've actually done work for themselves, but ask for an exemption from disclosing the clients or business or customers of the remainder of the law firm's clients or customers. The first requester is David B. Johnston. He's a school director with Snohomish School District. Second, Benson Wong, City Council member with the City of Mercer Island.
Okay, and in looking at Mr. Johnson's, he has stated the school district does not have any business relationship with this law firm. So there are no payments, there's no conflict there, and he has reported the other information. Mr. Wong also did a good job of detailing the client relationships and the recusal, which I also want to discuss with you when we get done with these in terms of recusal language that would be helpful. So with regard to these two, I will grant the partial modification in each as requested on the basis that literal application of the law would cause a manifestly unreasonable hardship on each applicant, and then a limited modification of this nature won't frustrate the purpose of the act. And Mr. White?
The next applicant is requesting a modification that would exempt him from disclosing his spouse's reportable business customers. Applicants are allowed to request a modification when their spouse, the information that would be required and reportable for their spouse causes the hardship. In this particular case, that is the request that Mr. White is making. William Allen White is a commissioner with the Grant County Hospital District Number 1.
And he stated that he has no ownership interest in the company, not involved in day-to-day operations, and that he too would recuse himself if there's any matter that comes up.
That is correct.
All right. So similarly, I will approve this partial modification as requested on the basis that literal application of the law would cause a manifestly unreasonable hardship on the applicant, and that this limited modification will not frustrate the purpose of the act. And then Ms. Janicki?
Next applicant is requesting a modification that would exempt her from disclosing reportable business customers with $12,000 or more. This particular application applies to both the information that would be required to be reported on her own behalf as well as that of her spouse. Over the last several years that Ms. Lisa Janicki has requested this modification, her ownership in the company has changed, so that is why it's being requested in this particular manner. She is a commissioner with Skagit County, and the details of her current ownership and her spouse ownership are listed in the cover sheet.
Mm-hmm. And again, she has attested that that business and its customers don't business with Skagit County, and that she has and will continue to recuse herself if there's any matter that comes before the commission where that is warranted. And just looking through, I had one. No, I think we've got that. All right. So with regard to this request, I will approve the partial modification as requested on the basis that literal application of the law would cause a manifestly unreasonable hardship on the applicant, and that this limited modification will not frustrate the purpose of the act. And our last one is another judge.
That is correct. The final applicant is requesting a modification in two different sections of the rule. The first one is an exemption from identifying residential address. The second is an exemption from reporting the spouse's reportable business customers. In this particular case, the identification of the spouse's reportable business customers relate to a law firm. Her husband is a member of Gordon Thomas Honeywell, which is a pretty well-known law firm. She has disclosed the reasons behind that request and identified her very limited access to that information, and identified the reportable business customers that clients that are known to her, as well as the other information that's required for her request to exempt her from identifying her residential address.
Mm-hmm. Very good. And she too has stated that per the Code of Judicial Conduct, she would recuse herself in any matter where there's a potential conflict. Okay. So on that matter as well, I'll grant the request for partial modification on the basis that literal application of the law would cause a manifestly unreasonable hardship on the applicant, and that the limited modification will not frustrate the purpose of the act. Are there any other requests to come before us this afternoon?
There are no others for this particular hearing today. Thank you.
All right. Then we'll adjourn this. We'll conclude this hearing, and we can go off the record. And thank you very much.
You're welcome. Just give me just a moment to stop the recording.